The chromatography part at the beginning, basically it's a tube, and in that tube is some little particles, and based on what the shape of the molecules are that we're looking for, they're going to interact with those molecules in there differently depending on what it is. So it kind of just travels through there in a liquid, and then the detector part at the end basically shoots some electrons on it, and then you end up with a mass spectrum, which is a kind of a fingerprint. So if a particular compound gets bombarded with electrons, then it's going to split up into pretty consistent pieces each time. So we're looking at like the comparison of what those pieces are.
Okay, thank you. Do you know when you performed the analysis on this sample?
I did it on April 25th, 2024.
And when you perform an analysis of this nature, are there procedures to verify the accuracy of the result?
Yes.
And what are those procedures?
The first thing we do is the beginning of the run is what's called a calibration, which basically teaches the instrument what the different levels of that compound are going to look like. And then, so that's the first 6 samples. We run a negative to make sure that there's nothing in our system that is producing a positive result when it shouldn't. And then we run some cases, and then about every 10 or 15 samples, there's a control where we're checking that calibration. The controls are known samples that we know what the result should be. And we make sure that we put those in place throughout the run to make sure that we are getting accurate results. So those include 3 positive controls, 1 negative control, and then a control that we actually purchase from another company that comes verified at a certain concentration to make sure that our results are accurate.
And that was done in this case?
Yes.
With the testing of this sample?
Yes.
And you indicated during that answer that all the instruments in this case are previously calibrated?
Yes, I calibrated when I ran my batch.
Okay. And everything, when you ran this sample, was in good working order?
Yes.
And Ms. Beecham, these methods that you use to test this blood sample, are they accepted in the scientific community at large?
Yes.
And were you able to obtain a result for any drug from the sample you tested for the defendant in this case?
Yes.
Did you prepare a report regarding that?
Yes, I did.
I'm going to make sure I only have one document stapled together this time for you. I'm going to show you what's been previously marked People's Exhibit 22. Do you recognize that document?
Yes.
And what is it?
This is a supplemental laboratory report for our laboratory number TX24-5842 for a subject of Marcella Chittister.
And why is it a supplemental report?
The alcohol analysis is always the first report, so anything after is a supplemental report.
Okay. And is that document dated?
Yes.
And it's April 25th, 2024?
So the date on the report is the date that I wrote the report, which was April 26th. I did the analysis on the 25th, but it runs overnight. It has to be reviewed. It takes a day.
Okay. And you signed that document?
Yes.
And does that meet the criteria for reporting for the Michigan State Police Crime Lab?
Yes.
Judge, at this time, people would move to admit Exhibit 22, supplemental report prepared by Samantha Beecham.
Response. No objection. People's 22 is admitted.
And Ms. Beecham, if you could read off your report to the jury what the result was for the drug analysis run on defendant's blood sample.
I detected and quantified gabapentin at 1.3 micrograms per milliliter.
And Ms. Beecham, do you know what gabapentin is?
Yes.
Can you explain to the jury what it is?
Yes, it is a medication that's often sold under the brand name of Neurontin. It can be used for things like seizure disorders. It can be used for pain relief. There's a couple other off-the-label instructions for things that can be prescribed for, but those are the 2 main ones, seizures and pain.
And does it have a drug classification?
Yes, it is considered an analgesic, it is a central nervous system depressant, which means that it has the ability to slow down the nervous system.
Okay. If I could grab exhibit 22 up front. And clinically, Ms. Beecham, can you say whether gabapentin has any noted interactions with alcohol?
It can. It depends a lot on the individual, their dosage, how frequently they use alcohol and the gabapentin at the same time. But alcohol is also a central nervous system depressant, so it wouldn't negate those effects.
So would it be fair to say that consuming the two together could exacerbate their effects?
Correct.
No further questions, Judge.
Cross?
Good morning, if it's still morning. My name is Bill Colobus, and I'm the attorney representing Marshall and Chester, the defendant in this case, okay?
Okay.
And I'm going to ask you a few questions. You know, when attorneys say that, it's usually, 20, but I'll try to keep it very, very short, okay?
Okay.
All right, and then just keep your voice up for the court reporter and the court to be able to hear you, okay?
Sure.
Thank you. How long was it that you've been working in your role right now?
My current role, almost 2 years.
So at the time that you did this testing that you spoke of, you were doing your job employment-wise for about a year?
As a supervisor, about a year. As a forensic scientist, I'd been there about 15.
Okay, thank you. Now, I'm going to just jump around for a moment. You had just said in response to the prosecutor's question that this drug can be used for seizures, correct?
Yes.
And it's a lawful drug as long as you have a prescription and you're not overusing it, correct?
It is a prescription-controlled substance, yes.
And you said it's used for seizures. What else is it used for?
It can also be prescribed for pain.
And then you didn't have anything to do with putting any preservative or any particles, substances in the tube prior to the blood going in the tube. Have you had anything to do with that?
No.
Does a company do that, or does the state of Michigan do it?
We contract with a company, and then every time they send us a shipment of those boxes, then we get a certificate of compliance that they put those in there.
Okay, so a private company does it.
Yes.
You don't have anything to do with checking the standards or things like that. You just strictly toxicologist. You do the testing.
Correct.
And the sample, or excuse me, the amount that's given to you or the sample of blood is only as good as the sample is. Your test is only as good as that, correct?
Yes.
And if there's a flaw in the blood that's given to you, then do you agree that your test results are your results, but they're not accurate?
Depends what the flaw might be. A lot of things, it depends what the flaw would be.
Some are serious flaws, some are not, right?
Correct.
Okay. Why do you said that before you tested this sample, excuse me, on the 25th of April of 24, where did you get it from? Where was it?
It was in a refrigerator.
Okay, why is it in the refrigerator?
We keep things in the refrigerator for two reasons. One, it slows down if there is any growth. We keep all of our evidence in there, so urine bottles are not preserved at all. So we keep everything in the refrigerator in case there's any growth of bacteria. It will slow that down, and it also slows down the degradation or the decrease of different drugs that we may be looking for in the future.
Does it slow down? I use the word fermentation too.
It can if fermentation were even happening.
Okay. And you said, and that's interesting, urine, a urine sample does not have to be refrigerated.
It is refrigerated. It does not have any preservatives in the bottle.
Okay. And the blood is supposed to have preservatives in the tubes?
Yes.
And there's two tubes, correct?
Yes.
Okay. And then you did a test on this, correct?
Yes.
On this blood that you spoke of with the prosecutor, right?
Yes.
Okay. And then it had a result of what?
It was 1.3 micrograms per milliliter of gabapentin.
For us not scientific people, what would be micrograms per milliliter?
It's just a concentration that we use. So a lot of drugs are nanograms per milliliter, which is a billionth of a gram. This drug is such that we report it in micrograms, which is a millionth with an M of a gram.
So when you check the concentration of it, and you say 1.3, if it was nanograms, it would be 1.3 billion, correct?
If I were
So
reporting my result in nanograms, it would be 1,300 nanograms per milliliter.
It's a minute amount if you check that, correct? If you went by that scale.
I went by the scale that I measured, so it's a concentration.
So if you go by 1.3, and the UG stands for what?
Micrograms,
The ML stands for what?
milliliters.
Okay. And micrograms, again, at least so I can understand it, micrograms is, what's the millionth of what?
It is one microgram is 1/millionth of a gram.
1 millionth of a little tiny gram.
A gram is actually like a handful.
And it's 1 millionth of that.
Yes.
And you never interviewed my client, am I correct?
Correct.
And you never saw my client at all. You said you never interviewed her, but you've never seen her, would you say, other than today?
Correct.
You never sat down and talked with her and asked her any questions?
I have not.
Asked and answered.
Yeah, I think that's fair.
I've been pretty good, Judge. Did you get a chance to talk with the prosecutor or anybody from their office prior to today?
Yes.
When did you do that?
I'm not sure the exact day. It was one day last week.
Okay.
Maybe Wednesday.
And you didn't talk to anybody prior to that?
I don't think about anything specific. I may have, told them that I had a subpoena. I was supposed to be at a training this week, so we discussed logistics, those sorts of things.
And were you moved to today instead of another day this week?
I believe I was always going to be today.
And you and the other toxicologist, you both drove up here together?
Objection, relevance.
Did you, and then I'm going to ask her a follow-up question. It's just, did you drive up here together from Lansing, drive down here?
I'll take the answer. I'm not sure how relevant
Thank
it
you.
is, but
Did you drive together from Lansing today?
With Ms. Faust, yes.
Okay. And, did you discuss court at all today?
We discussed logistics, who was going to testify first, what we had with us. I haven't seen her much since I've been out of the office. We didn't discuss specifics about this particular case or what we would testify to.
I don't have any other questions, Judge.
redirect.
Very briefly. just, stupid math question. 1/1,000,000th of a gram is the kind of the number that Mr. Clovis said, but that's for every single gram in the body, is that right?
Correct.
He asked you some questions about the cold storage at the lab, and you gave an answer that just in regards to fermentation, if any fermentation was happening. Could you expand on what you mean by that?
Yes, every sample is not going to be fermenting. So if fermentation were happening, if you're going to make wine or beer, that needs to not be done in a refrigerator. That will slow down that process significantly. So if there were fermentation happening, you would want it to be slowed down in a refrigerator, but not to say that it was in this case.
Okay. No further questions?
Any recross?
Just 1 second, Your Honor, please. I don't have any other questions, Your Honor.
All right, may this witness be excused.
From the people, well, no. We'd like her to remain as a potential expert rebuttal witness.
All right, you're all set for the time being.
Thank you.
Next witness.
Judge, people have no further witnesses. People rest their case in chief at this time.
All right.
Your Honor, you need to approach or would you?
Yeah, why don't you approach?
Okay, thank you, sir.
We're going to take a little bit of a break, so if you'll follow Deputy Huff, and we'll be back in a few minutes.
You may be seated.
People of the state of Michigan versus Marshall Disaster.
Be seated, please. All right, so the people have rested. Do you have a motion you wish to make?
Yes, Your Honor. It's a motion for directed verdict with regard to the proofs the court heard, all the proofs of trial testimony and saw the evidence. Your Honor, we ask that a directed verdict of not guilty be based on the counts based on, well, the first is that the alcohol testing was had acetone, and acetone is fermented, actually could be deadly solvent sometimes on which, in my opinion, it produces inaccurate results. I understand, Your Honor, totally that the expert said that those were accurate results. Number two is that the search, that the warrant was not proper. And I don't arguing this, but I'll just refer to our prior arguments. I did do a rehearing motion that dropped off. I hand-wrote things in because it was a late hour. Yesterday, I dropped it off at the court with regard to the prosecutor that signed and approved. So there was ex parte communication there, knowing that I was representing him. So we asked that that be stricken. And also, it being, we argued this before, so I just refer to our prior motion and ask for a directed verdict based upon part of that reason, is that it was private property membership only. Anything with alcohol would be excluded. Thank you, Your Honor.
Thank you, Judge. As to Mr. Clovis's last 2 points, those are motions that have already been decided by the court and ruled against. I don't think those are valid bases for a directed verdict. As to the first tenet of Mr. Clovis's argument. That's for an expert to say, Judge. Mr. Clovis's opinion doesn't merit the court's time in that realm.
Your Honor, there was one third one, and I apologize, that there's been no proofs whatsoever that there was any type of specific intent or any type of intent by my client, which is required for second-degree murder. Thank you.
All right, you can address that as well.
I'm sorry?
All set now?
I'm all set, I apologize,
Good.
yes.
So, judges, as to our response, people have established date, venue, and the ID of the defendant. Beginning with counts 3 through 9, the court was able to view the body-worn camera from Sergeant Bomia, Deputy Karina. Defendant acknowledged her operation of the vehicle in both videos. The blood and gabapentin came in without objection. They showed the defendant's level of intoxication at a .18. They also show the presence of gabapentin at 1.3. The court would have to refer to the report for the numerical value. The medical examiner's report, which were both stipulated exhibits, established the cause and manner of death for the victims, Zane and Alana, that both died as a result of multiple blunt force traumas, the result of a car collision. The medical records, which were stipulated to, and beyond even that, the stipulation that the named victim's injuries rise to the level of a serious impairment under the statute. Those were stipulations. So for victims Diane Medina, Ed Smothers, J.B. Phillips, Mariah Dodds, and Leah Stiff, those are all stipulated to as the result. So you've got operation, intoxication, date, venue, and the resultant injury. There's also ample evidence of causation, but for the defendant's operation of the vehicle, none of those things would have happened. So for those reasons, people think they've made a sufficient showing on counts 3 through 9. As to counts 1 and 2, people incorporate the proofs previously noted, and that the named victims died as a result of the defendant's actions. The people have established for the court that the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. Specifically, the defendant possessed a blood alcohol content of 0.18, the legal limit being 0.08, the high BAC limit or super drunk limit being 0.17. The defendant acknowledged to Deputy Karina that she believed she was a 7 out of 10 for intoxication. Maybe more importantly, though, is that she should not be driving. In the Michigan Supreme Court case 1998, People versus Goki, the Supreme Court found that there were certain factors that a finder of fact may consider to support a charge of second-degree murder, and they relied somewhat on the Michigan Appellate Court case of People v. Aldridge, in which a defendant operated her vehicle at an excessive speed. In that case, it was 45 miles an hour in a parking lot, and excessive speed was held to be a factor that the finder of fact could consider in determining second-degree murder versus a different type of charge. The defendant left the scene of a property damage accident in this case. That was the crash she caused by backing out of her driveway. In the unreported case of People versus Del Piano, it's a 2012 case by the Michigan Court of Appeals. It can be found in Westlaw 304-6157. That case found leaving the scene of a property damage accident prior to causing a death to be a tenet that the court could use to determine that second-degree murder is support. And finally, Judge, the Gecki case, the Supreme Court case, notes that in all cases of this nature, in order to sustain the intent element of second-degree murder, the incident should have an overall egregiousness factor. Here, people point out the defendant's high BAC, not only twice the legal limit, but above that. Also, the gabapentin in her system. She acknowledged to Karina she was intoxicated, scoring herself a 7 out of 10. She left her home in that condition, knowing she was traveling to a small child's birthday party. For those reasons, Judge, people think they have satisfied the intent element for second.
All right, thank you. Last say so, Mr. Clovis.
By analogy, I argue is somebody sees a yellow light and this is relation to intent. Somebody sees a yellow light, they choose to speed through the yellow light, there's a crash, and that's stop. That's intent, and that would be the type of intent in this case. It lacks any intent because she didn't choose to do, whatever they claim she attempted to do is murder somebody. Absolutely not. If anything, that's the furthest of what took place. She didn't even understand what happened, whether it be spasms or whatever.
All right, thank you. So the court is required to review all of the testimony that's been taken in the light of, in favor of the prosecution, making a determination whether there is a sufficient case to send the matter to the jury to make a decision. Let me address some of the preliminary issues. First of all, the testimony and everything we saw, it's clear that this happened in an area that was accessible to the public. In fact, taking a look at those photos, you really can't tell where the road stops and the parking lot begins, but clearly it is all accessible to the public. Second of all, the question regarding the warrant, I ruled on that yesterday. I acknowledge receiving what was called a rehearing, but the allegation was made that an attorney from the prosecutor's office had ex parte communications with the magistrate. That is a serious allegation, and without any support, I find it's a reckless allegation. And when I take a look at what was attached as an exhibit, prosecutors sign off on these all the time. In fact, every one I've ever seen, prosecutor signed off on. This prosecutor signed off the day before the affiant signed it. There's nothing in here that shows there's been any contact whatsoever with between the prosecutor and the magistrate. So that leaves us really with the charges themselves, what I consider more the core issues. As it pertains to the second-degree murder charge, the elements, and as it pertains to both children, is that the defendant caused the death of those children, that they died as a result of the defendant knowingly creating a very high risk of death or great bodily harm, knowing that the death of such harm would likely result from her actions, and by driving while intoxicated or recklessly under the influence of alcohol or gabapentin. Second, that the defendant had one of these three states of mind. She intended to kill, which is the intent question that defense raises. She intended to do great bodily harm. Or the third one, she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the result of the actions. And I do find that the testimony supports all of the elements for second-degree murder. The Goki case is exactly on point. We have an overall egregiousness here, at least the argument will be, and certainly it's for the jury to decide. We have a blood alcohol of 0.18, which has been admitted. The issue of the acetone, that's for the jury to decide. We have a high BAC. We have the use of gabapentin with the alcohol. And then we have the video showing the defendant backing out of her driveway and running into the neighbor's car. Maybe that should have been the time to kind of keep an eye on things, but then charging forward all the way through the building. As it pertains to the operating while intoxicated causing death, the elements are different, but it has to do with the intoxication, and clearly the evidence is in, at least for the jury to decide that she was operating with an alcohol content of 0.18. Further, that it caused the death of both Zane and Elena. As to the other charges, those are all operating while intoxicated, causing serious injury. I've mentioned the intoxication, I've mentioned the operation, and there's been no contesting of the injuries. For all of those reasons, a motion for directed verdict is denied. You bring the jury in, please. You may be seated. Welcome back, ladies and gentlemen. Thank you for your patience. We appreciate that. The people have rested, and because, just like I said yesterday, sometimes the logistics of getting witnesses where they need to be, we're going to send you home early for lunch, and we're going to come back. I'm going to ask that you be back in the jury room at 1:15, and the defense will put on a portion of their case at that time. I'm going to remind you that you're not to discuss this case with anyone, including each other. And again, reminding that once you're in the building, that you go directly to the jury room, and I would ask that you be in the jury room at 1:15 sharp. Thank you for your hard work this morning. We'll see you this afternoon. You may be seated. All right, so we are going to go back on the record at 1:15 sharp. For those of you, I have another matter that I have to handle at 1 o'clock. So the court will be operating at 1 o'clock, just not on this case. This will be at 1:15. All right, we're adjourned.
All rise. Court is back in session. You may be seated.
People of the state of Michigan versus Marcella Tavern.
You ready to go?
Ready to go, Your Honor.
Okay, bring in the jury, please.
Your Honor, as my witness, Officer Quinn, should I go get him or go before Officer Quinn? He's right outside the door.
You should get it.
Okay. Do you want me to go right now?
All right, welcome back, ladies and gentlemen. You may be seated. People have rested, so the case is now with the defense. Your first witness, Ms. Flo.
Thank you, Your Honor. May I approach the podium?
Sure.
Thank you. I want to call Lieutenant Ryan Quinn. Thank you.
I'm going to swear you in again because it was a day or so.
Do you solemnly swear or affirm that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I'm just going to have you state your name, please.
Good afternoon. My name is Brian Quinn.
All right, thank you. Go ahead.
Okay, thank you. As you already know, probably, it's Bill Clovis, and of course, I represent Michelle Bedford, the defendant. We had an opportunity where questions were asked the other day. You recall that, correct?
I do.
Okay. And you're just very lightly to go over, you interpret traffic crash recorders. What is the fancy name for them, or the actual name?
Event data recorders or airbag control modules.
Okay, all right. And you download it and then you interpret it like you described the other day, correct?
In this case, Deputy Burkhardt imaged the recorder and I read it.
Okay, all right. And then you go by what's recorded, the images, am I correct?
Correct.
And for lack of a better word, it's like the black box of an automobile.
It is.
Okay. When you described before that it was showing moments before impact back on April 20th, 24 at about 3 o'clock in the afternoon. Moments before impact, Ms. Chevister's vehicle took off. I mean, first it backed up, and it backed up with force, or, driving fast, correct?
Yes.
Okay. And then that, her vehicle hit a tree, and then also the neighbor's truck, and it knocked down part of a fence or a fence, am I correct? correct?
Correct.
Okay. And then you said, according to the data, the vehicle took off and started proceeding straight ahead in the opposite direction of backing up, and picked up speed, for lack of a better word, picked up speed, and probably didn't stop at all. Is that correct?
Correct.
Until it actually hit the wall, the outside wall of the boat club, and then went in about 25 feet, right?
Well, after it struck the outside wall, it continued in motion until it struck the wall inside of the venue.
Okay. And then you had testified that the vehicle take off from zero when it got back into drive, and then reached speed slowly of about, I don't know, 42, 43, 44 miles an hour. Is that correct?
I believe at impact it was 44.3 miles per hour.
All right. You know the numbers better than I do, but you live them. And there was no prior braking until, of course, the vehicle hit a wall or hit something that was stationary.
At a complete stop, yes. Prior braking, the image itself showed that there was no braking, but there was a indication on the image that showed part of braking, but also part of 100% throttle.
Okay. And then you had informed me that you were in the hallway, we made small talk for a minute, that when it reaches 70 or more, that's considered what?
Through my training, anything that's 70% or more is considered 100% of throttle.
100%
Of throttle,
throttle, full power throttle.
yes.
Okay. And there was one stage that you were showing braking and the throttle at the same time. Is that what you just said?
Yes.
Okay. Now, would that be indicative of somebody that's having an attack and they're touching the brake and the gas at the same time?
Objection calls for speculation.
Response.
Uh,
No, from him, not you.
In his years of being a patrol officer, I'm asking him in his years of being a patrol officer, has he ever come across that, I guess is what I'm looking at. Do I need, maybe I need proper foundation?
Let's do that.
Okay, thank you. Officer, how long have you been a patrol officer?
Total amount of years is 35.
And right now is it a lieutenant?
Yes,
How long have you served in the lieutenant capacity?
for 2 years.
And you've never had any, lack of a better word, demerits or anything like that with regard to your job, am I correct?
Oh, I have.
Oh, you have?
Yes,
Come
we,
across like you never did.
we,
Okay.
we call them counseling notices.
Okay, all right, but have you ever had it where you weren't interpreting something properly? Such
No.
as what you're testifying to today?
No.
And and you've done, I presume, hundreds if not thousands of accident investigations. Would you agree with that?
That's fair.
And have you ever had it where somebody is driving and they put the brake and the accelerator on fully?
I've had experience with operators of vehicles where, and everybody's unique, where some people drive with both feet, where that can cause that type of indication.
Have you ever investigated any cases where somebody has a medical issue, such as a seizure, and both feet go to the ground, or go to the pedal area of brake and gas?
I've investigated many crashes where there's medical issues. However, I'm not really qualified to say whether or not of their actions at the time of the crash. I don't know what happened at the time.
Okay, and you know, I appreciate your honesty. We all do in this room. Thank you. But you're sure that looking at those reports over the years of your experience, that it looked like brake and gas was going simultaneously, at least for a second or two?
Not very much. I'll be quite honest, this is the first time I've seen this in a long time.
Oh, no, I'm sorry. As to this case, as to this case, does the report indicate of your interpretation that the breaking gas, at least for a second or whatever, was simultaneously?
But that's correct, for half a second.
I don't have any other questions, sir.
Cross?
No cross on that.
All right, may this witness be excused.
Yes, Your Honor.
All right, thank you,
Thank you, Judge.
Lieutenant. You're excused. The next witness?
Thank you. I'm gonna go out and hope my client's here. It's
All right.
supposed to be here at 1:15.
All right. The name of your witness?
I'm sorry, Kelly Thornton.
Okay.
And that's Thornto.
Do you solemnly swear or affirm that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am? Watch your step. Make sure.
Would you state your full name for the record, please?
Kelly Ann Thornton.
All right, Mr. Williams.
All right, thank you, Judge. Ma'am, my name is Bill Clovis, and I represent Marcella Register that's sitting at the table there. Do you know her?
I do not personally know her.
Oh, okay. I appreciate you coming here today. The schedule sort of got moved up a little bit because the trial's moving along much quicker. So the only people that are probably really happy is the jury. So I apologize to all of a sudden from Thursday turned into today. Where do you currently work? And I'm told that you have more than one job.
Verna's Bar and Grill.
Verna's?
I'm a
Okay.
travel agent.
I'm sorry?
And I'm a travel agent.
Okay. And Verna's, I know you have a cold or you're ill right now.
Yeah.
And so thank you again for showing up today. How long have you worked for Verna's?
Part-time for about 4 years.
Okay. And like, how many days a week do you work?
2.
Okay. And back on April 20th of 2024, last year, do you remember my client coming into your tavern?
Yes.
And about what time would have that been, if you recall?
She got there right when I got there at 11 o'clock.
11?
Yes.
Okay. And was she there with somebody or meeting somebody?
Her friends, Brenda and Peter.
Who were her friends?
Brenda and Peter.
I'm sorry, their last name.
I don't know.
Okay. And have you known them for a while?
As long as I've known of her.
Okay. And on that day, how long did they stay there?
About an hour.
Okay, did they all stay and leave together, or did some stay?
I did not
later?
see her leave.
I'm sorry?
I did not see her leave.
Okay, and then what to do is the court reporter will get mad if we talk over one another, because she's got to type it, so I apologize. I'll wait for you, and please wait for me. Do you remember at all what they ate or what my client ate, if she ate anything that day?
I got her a cup of white chicken chili.
White chicken chili.
Yes.
Did she have a sandwich or anything?
No.
Do you have, my clients informed me that she had a fish sandwich or something, but that may not be true, or you just maybe don't remember?
It was not on her bill.
Oh, okay. And was there any alcohol?
A wine and a water.
I'm sorry?
1 glass of wine and a water.
Okay. And do you have like specific detailed recollection of that day, sort of that moment of her being in there? Do you have a good memory on it?
No.
The best you can?
Yeah.
Okay, now, did you remember that 1 glass of wine and that chili soup? Did you remember that by refreshing your memory by looking at something, or did you have your own independent recollection?
My own independent recollection.
Those are just a bunch of fancy words, but we gotta put that on the record. Now, the glass of wine, did she just have 1 glass of wine? Did she have more than that? Did she have anything else to drink other than that water you mentioned?
No.
And did she finish the wine?
I don't recall.
There's a report that was made up by, I believe, an officer, and he said that there was still some wine left. Would that refresh your memory, or you just don't?
Judge, I'm gonna object. I don't know how she would have any knowledge regarding what's in the police report. Additionally, he's referring to hearsay. So-
Also assume something not in evidence. The objection is sustained.
Okay. You're absolutely positive that my client didn't have more than one glass of wine?
Absolutely positive that I did not serve her more than one glass of wine. But there's two of us that work on a Saturday morning.
Okay, well, did you see, did there come a time where the police came into the tavern?
Yes.
Okay. About what time did they come in?
6:37.
Okay, could have it been a little earlier, or? you sure?
Saturdays are busy, so
Okay. And why did they come in? What did
they
tell you?
said it could or could not be involved with the boat club.
Okay, and did they sort of close the place down, or did they come in and have lunch?
Oh, they came and closed us down
Okay, and did they close you down for a while?
that night.
Okay, and did they come in with a search warrant?
They did not give us one.
Okay, well, who else was working with you?
At night, it was Amber.
And you don't remember a search warrant?
Nope.
Would have anybody else met them at the door or talked to them that they would have gave any papers to?
It was me and Amber, and we just called Kelly, and she came right over.
And do you remember that they wanted to look at a receipt of any charges?
We gave them the receipt.
You gave them a receipt
Yes.
of who?
Peter, Brenda's, and hers.
I'm sorry?
Peter, Brenda, and hers, because they were all at the
And
table
hers
together.
is who? Who's hers?
Oh, Marcella.
Okay, and that receipt, was it a charge, cash, or debit card?
She paid cash, but Brenda and Peter paid with a card. That's why we were able to find it easier in the computer system.
Okay, and do you recall at all how much the bill was?
No.
Okay. Do you remember what was on the bill that showed proof of purchase?
I don't understand.
The receipt, what was on the receipt?
Water, a glass of wine, and a cup of soup.
Okay. I just, and I apologize, it's just I have to make a record like this for the jury or the judge. And, you may live it and know it, but other people don't, so thank you for your patience. And then, did you give the police or the sheriff a copy of the receipt?
Brooke did.
Okay, she made a copy and then she gave it to them.
She printed it off the computer.
Okay, now, after 11 o'clock and my client left the tavern, Verna's, did she ever come back again that day?
No.
And would you have memory if she did?
Yes, her husband was there about 3 o'clock that day.
Okay, and what was her condition? Well, you said she stayed about an hour,
About an hour.
so she would have left approximately like noon?
Well, her ticket, when we printed it off, said she cashed out at like 12:15.
12:15?
Yes.
Okay. I will presume that's when she left.
Right.
Right, okay. And what type of state of mind, how did she seem? Did she seem intoxicated? Did she seem like you and I are talking, completely, sort of sober or whatever? How did she seem to you?
I told you I did not see her leave. Brooke cashed her out.
Okay, well, how did you waited on her, correct?
When she first got there, yes.
Okay, while you were waiting on her for that approximately hour and 15 minutes, how was her mannerisms? Did she seem like she was drunk, falling down drunk, slurring?
No.
Okay. We weren't there, that's why I'm asking.
No, you're
And
fine.
this is important, okay, thank you. Did she seem like she was intoxicated?
No,
Would you served her if she was intoxicated?
absolutely not.
Okay. Have you taken any training with the state of Michigan or anything concerning that?
20 years plus.
I'm sorry?
At least 20 years.
Okay. And you're sworn to tell the truth today, and you're saying that she was absolutely not intoxicated when she left your premises that day. Is that correct?
I'm
Judge,
not-
I'm gonna object, this calls for speculation. She's already given her opinion regarding her state.
I think she has answered it. In fact, she said she didn't see her when she left, but she did say she was not intoxicated when she served her. I think.
Thank you. If I could just have one moment. Find something. Of course, I had this earlier, and I apologize for taking the time right now to witness. I'm looking for the receipt. You didn't have the receipt, would you?
No.
I'll ask the prosecutor that, I believe you stipulated, we'll stipulate to the receipt so we can have this witness, move on.
People did sign a stipulation regarding this receipt. Once Mr. Clovis is able to produce it, people will review it. If it's what we think
If it's the
is,
same, we'll enter. Okay.
Okay, very good, Judge, just move it along. And I'm sorry, I was not prepared on that one. Is there, you still work there?
Yes.
Burnos?
Yes,
And, who owns it? Is it Kelly who?
Kelly Sylvie.
And, well, I don't have any other questions, Your Honor, at this point.
Cross?
Very briefly, Judge. Ms. Thornton, I know this was asked of you a number of times, but you remember Ms. Chidester arriving at 11 o'clock that day, correct?
Approximately, yes.
Approximately, and then she left at approximately 12:15, correct?
I did not see her leave, but that's what time her cash out was.
Okay, gotcha. And do you have any knowledge if she consumed any alcohol prior to coming to Verna's?
No,
Okay, and you don't know if she drank anything after she left Verna's at 12:15,
absolutely not.
right?
Yeah, no.
Okay, that's all I have, Judge. Thank you.
Can you redirect?
Please, ma'am, she just asked you about drinking prior to, that you don't know if my client drank any alcoholic beverages prior to entering your premises, correct?
No, I don't know.
Did she look like she was intoxicated when she entered your premises?
No.
All right, thank you. No other
All right, may this witness be excused?
please.
Thank you for being here. We
Thank you.
That's all we have, right? All right. Ladies and gentlemen, again, I'm going to sound like a broken record, but logistics have thrown a wrench in the works. We would have let you know that earlier, but we were really hoping to pull the feet out of the fire there before and have something for you. We do not. So the bad news is we're done for today. The good news is we're done for today. Tomorrow when you come in, and again, I'm going to ask that you be in 8 o'clock, 8 a.m. sharp. When you come in tomorrow, you'll hear the last one or two witnesses, you'll hear the closing statements, and you'll hear the final jury instructions. So that will happen tomorrow. As always, don't discuss this case amongst yourselves or with anybody else. And again, when leaving the building or entering the building, right to and from the jury room. Appreciate your hard work today. Have a nice afternoon, and we'll see you 8 a.m. sharp tomorrow.